Hello, everyone. It's been a while. It's good to be back. Today we have an indictment hearing. It's based off of two domestic violence situations, and this is just part one. You're going to see the testimony from someone that works with a 911 operator. It's interesting to see how the law is starting to work as far as like advocating for women who are going through domestic violence, like assuring that their abuser serves their time and, is required to like do things that are going to correct that behavior. So let me know what you guys think in the comments. Like and subscribe.
State of Texas versus Dodson. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense.
Elizabeth Russell for Todd Dodson.
And are you Mr. Dodson?
Yes, Your Honor.
And co-counsel?
Haley Hughes for the defense.
All right, my understand. Oh, you may be seated. You all can be seated. And throughout the trial, if you remain seated for your objections, I don't take that as a sign of disrespect, but it's easier for the court reporter to hear. All right, so defense, you have motions in limine?
Yes, Judge. As we discussed yesterday, we have one motion in limine that's been filed and served on the state, and then we had an oral motion in limine as well. On the motion in limine number one that is served on the state and filed, we request that no extraneous offenses or any evidence of wrong or bad acts be introduced without first approaching the bench. Specifically, there's allegations that Mr. Dodson has contacted the complaining witness while in custody by both phone calls and letters, and the state had actually asked for a continuance to give us this evidence, specifically the jail calls several months ago. We never got this.
All right, and my understanding from conversations yesterday off the record states you're not bringing any of that into evidence. Is that correct?
That's correct, Your Honor.
All right, next.
And then we had an oral motion in limine that the complaining witness not be referred to as a victim until it's been adjudicated. So we had an oral motion in limine that the complaining witness not be referred to as a victim until it's been adjudicated as so.
All right, and that's standard here in the 187 District Court. And off the record yesterday, the state said they would abide by that. All right, so if there's any other extraneous approach first.
Yes, Your Honor. Just as a...
Just 1 second, I'm sorry. And if the state will make sure they'll make all of their witnesses aware of the motion in limine.
We have spoken with the complainant and the eyewitness this morning, and we made it unequivocally clear on multiple occasions to not talk about those things that happened after the latter date of offense, Your Honor.
All right.
Thank you.
All right.
And
I know it's hard.
It is a bad habit, Your Honor, and
No. When I was in other courts, it was always stand. But then when I was in Judge Knowles' court as an attorney, and they had all of the technology before they had it on the criminal side, he ordered that everybody sit. And if you continued to stand, he would start fining people. So, of course, I won't do that here.
Thank you, Judge. I will rack up a bill. Your Honor, just as a small bit of information for the court's knowledge and context, we have we have basically, of course, 2 counts and 2 dates of offense. We have a 911 phone call wherein the complainant mentions that the defendant is on parole. So we're currently working on basically redacting that specific section.
Okay.
And we just want the court. So we plan on putting the custodian on, basically laying an authentication predicate, but we won't publish until we have that redacted copy wherein a mention of parole was not on that.
Okay. All right. Thank you.
Yes, Judge.
All right. Is there anything else?
And then, Your Honor, the state also has a motion to fingerprint for the court's knowledge as well.
All right. As soon as we take a break, we will hear that. And then my understanding from... No, that's fine. My understanding from the other prosecutor in this court that there's a shortage of fingerprint examiners. So make sure you call them. And when we have a break, we can do the fingerprinting and counsel. That's just to move things along quickly. But if you have an objection to that, the court will, of course, hear those objections. All right.
Thank you,
And
Judge.
I believe the jury is going to come in. All right, we're ready.
All right, so the juror.
All right, everyone, please be seated. All right, and I see that someone has brought a notepad, perhaps to take notes. This is what I tell jurors. I sort of discourage from doing that because, one, I want to make sure that you are 100% focused on witnesses and not on writing. And number two, whatever notes you take, you're not going to be allowed to have those with you during deliberations because the certified record is from the court reporter. So sometimes people may end up taking notes just in anticipation. And then somebody on the back may say, well, was somebody wearing a green sweater or red sweater? And then, a person may pull out their notes, say, well, I wrote down they had a green sweater. So I discourage people from taking notes for that reason, because if there's an issue about whether somebody, hypothetically, if somebody's wearing a green or red sweater, the person to tell us whether they were wearing a green or red sweater will be the court reporter. All right. So you all had an oath downstairs, but I'm going to give you the oath for this specific case. So if you all could raise your right hand for me, please. Do each of you solemnly swear or affirm in the case of the state of Texas versus Mr. Dotson, you will a true verdict render according to the law in the evidence, so help you God?
I do.
All right, you can lower your hand. If at any time you all have trouble hearing, just let me know. You can tap on your ear, you can raise your hand and say, I can't hear. And we'll make sure that everybody speaks up, all right? State,
Yes, Your
you
Honor.
may proceed.
Your Honor, would you like the state to read the indictment?
Yes.
In the name and by authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized, impaneled, and sworn as such at the March term 2023 of the 187th Judicial District Court of said county and said court at said term, do present in and to said court that in the county and state aforesaid, and anterior to the presentment of this indictment, count one. On or about the 9th day of January, 2023, J.L. Dotson, herein referred to as defendant, did intentionally, knowingly, and recklessly cause bodily injury to Denise Olivares, a member of the defendant's family, household, or person with whom the defendant has or had a dating relationship, herein referred to as complainant, by striking the complainant with the hand of the defendant. And before the commission of the offense alleged above, on the 16th day of August 2010, in cause number 97W in Bexar County, Texas, the defendant was convicted of the offense of assault family household, impeding the breath or circulation, an offense against a member of the defendant's family household or a person with whom the defendant has or had a dating relationship. Count two. And on or about the 17th day of January 2023, the defendant did then and there, intentionally, knowingly, or recklessly, cause bodily injury to Denise Olivares, a member of the defendant's family, household, or person with whom the defendant has or had a dating relationship, by striking the complainant with the hand of the defendant and grabbing the complainant with the hand of the defendant. And before the commission of the offense alleged above, on the 16th day of August 2010, in cause number 97W in Bexar County, Texas, the defendant was convicted of the offense of assault family household, impeding the breath or circulation, an offense against a member of the defendant's family, household, or a person with whom the defendant has or had a dating relationship, against the peace and dignity of the state.
All right. To that, how do you plead?
Not guilty, Your Honor.
All right, you may be seated. All right, State, are you prepared with opening statements?
Yes, Your Honor.
You may proceed.
Members of the jury, you just heard me read the indictment, and I want to really break this down. The state intends to put on evidence to show and demonstrate beyond a reasonable doubt that on January 9th, an assault took place, and on January 17th, an assault took place. So the state intends to call an officer from the first date, and of course the complainant, who's the same in both, but focusing on this January 9th, the state intends to put on evidence that will show that given a disagreement in the household, tempers were heating up, and the defendant spit in the face of the complainant and then slapped her across the face. Again, this is January 17th, okay? I apologize. January 9th. And then January 17th, the state again will call the complainant. We don't believe we'll have an officer from that date, but if we do, we'll put them on. But we will have the complainant, and the complainant will basically testify that the defendant came over to where she was living, and there was an altercation that took place after an argument, essentially hit her in her lower area and also punched her in the face. So again, I know I'm repeating myself, but just to be incredibly clear, the state is going to put on evidence that talk about two separate events, January 7th, January 9th, and January 17th. We'll have the complainant, the same complainant, talk about both. There was an eyewitness to the former. There was an individual that was there for the latter. She didn't see it, but she was in the next room. So out of totally proving our elements, giving the context, laying as much evidence as we can for both instances, the state is going to ask that you find the defendant guilty of both of these assaults against a member of his household or with whom he had a dating relationship.
Defense.
Yesterday, when we were talking on voir dire about how you determine a credibility of a witness, one of the big things we talked about was consistency. And so as we listen to the evidence today, I want you to look at the consistency of the statements, both of the complaining witness and of the other individuals that were there on both incidents. And the consistency that they tell the officers, the consistency of their own statements, and then the consistency of when they testified today. Because that's how we're going to determine the credibility of the story, right? That's how we're going to determine if it is what they say it is. And we believe that the evidence will show that not only are those consistent statements, not only is there not consistent statements, but that the assaults didn't happen the way that the complaining witness is going to try and tell you that they did. And based on that evidence, we'll ask you to find Todd Dotson not guilty at the end of all the evidence presented.
All right, state, call your first witness.
Yes, sir. The state is going to call a 911 custodian of record, Miss Robinson. And if I may approach the lodge left.
Yes. Oh, you may have a seat here. All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand. If you'll make sure you keep your voice up so the court reporter can hear and the jurors can hear. If you'll state your name for the record and spell it, please.
Lasanya, Lasonya, Robinson, Robinson.
All right, state.
Thank you, Judge. Miss Robinson, how are you today?
I'm good. How are you?
I am great, thank you. Now, you stated that you stated your name for the record, and we appreciate that. What do you do for a living?
I am a paralegal / custodian of records for SAPD Communications.
And SAPD, of course, I know it's a well-known acronym, but can you please tell the members of the jury where that is?
San Antonio Police Department.
Now, how long have you been a custodian of record?
Almost 3 years.
And in broad strokes, what does your job entail?
Upon request, we'll pull the 911 audio. We'll also listen to it and make sure that it hadn't been altered in any way, as well as review or generate the IDRs that were created at the time of the call.
And you mentioned the 911 calls. You mentioned these things called IDRs. Can you please explain what those are?
Those are incident detail reports that are generated once that 911 call comes in.
And ma'am, do you have anything to do with the creation of the record itself?
No,
Do you take the calls yourself?
no,
So plainly speaking, you keep the records.
yes, sir.
Now, regarding this incident, did you keep the records in the matter in hand?
Yes.
Your Honor, may I approach the witness?
Yes.
Ma'am, do you recognize these two things that I'm showing you?
Yes.
May the record please reflect that I'm showing the witness what's been pre-marked as State's Exhibit 1 and State's Exhibit 2. Now, ma'am, regarding both of these, what are they?
They are the 911 audios. One is from the 9th and the other one is from January the 17th and January the 9th.
It's not so someone can get the dates right. Now, how do you know that those are 911 phone calls from that day?
I listened to them.
You listened to them. And now, have they been altered or amended in any way?
No,
Do they accurately reflect the 911 phone calls that were made, respectively, on the 9th and the 17th?
yes,
Your Honor, the state would offer, again, what's been pre-marked as State's Exhibit 1 and 2 into evidence.
The judge would object under both the confrontation clause and hearsay.
All right, that objection will be overruled. State's exhibits number 1 and 2 are admitted into evidence with what was previously discussed.
Thank you, Your Honor. No further questions for this witness, Your
All
Honor.
right, defense.
Ms. Robinson, so when you reviewed the 911 calls for the 17th, when did you do that?
I did it on yesterday. Once I got the notice to come to appear for court, I pulled those 2 calls and listened to them.
And so on the 17th, there's actually 3 calls. Isn't that accurate?
Yes,
And there's only 1 call that has been added to the desk that you reviewed today.
yes,
Okay, no further questions, Judge.
All right. Is this witness excused?
For the state, Your Honor, yes.
Subject to recall, Judge.
All right. Just make sure you're available if anyone wishes to recall you as a witness.
okay.
All right, thank you. You may step down.